Hi there, I'm Dr. Suzanne Bechtel, a passionate legal educator dedicated to making legal studies clear, practical, and even a little inspiring. On this channel, you'll find a growing collection of videos designed to help you prepare for the Certified Paralegal exam. It covers key topics, breaking down complex concepts, and offering study tips that actually stick. If you're looking for a deeper dive, check out my Teachable School, where I offer structured courses, interactive tools, and exclusive resources to support your journey towards certification. Watch this video to the end and you'll find a coupon code for a discount. Don't forget to subscribe and explore the playlists. Your success on the NALA-CP exam starts here. Now, before we move on to the lecture, there are two important disclaimers. First of all, this is not considered legal advice. Everything shared here is designed to support your learning journey. Also, I am not a lawyer. This course is designed to help you understand the concepts of the exam. Thank you.
The second in a series of video lectures on contract law. This presentation, we're going to explore the core principles and types of contracts in law. And we'll learn through, as we clarify some legal terminology and examine some essential components and classification of contracts and build on to your foundation of contract law fundamentals. A little overview of what we're going to cover, our key objectives. Oops, I just covered that. All right, sorry, my finger went fast on that slide. So the key objectives, this slide is a reference to the key objectives. We're going to learn some legal terms mastery. There's several legal terms that are going to come along in this class. A long list, I noticed, in a book that I was looking at. Contract elements, so we can identify and recognize what elements of a contract need to exist for there to be a valid contract or an enforceable contract. We also need to look at the different types and classifications of contracts because they do have some very distinct characteristics. And quasi-contract types is also going to be covered and how they have a unique legal significance. They're interesting always. All right, some of the legal jargon and shorthand used in contract law as you're writing about it. You would use, we use terms like the suffixes in contract law, like payor and payee. This is something that I wish I could avoid it because it really does seem to, in some contexts, not so much in contract law, but the payor is a person who's to pay, and the payee is a person receiving pay, a monetary transaction. Some common legal shorthand that we use in law, we use a K to illustrate a contract. So if you take notes while you're working, you could say the K was a quasi-K or something, just put that K there. Plaintiff is a capital P and the defendant is that little pi. And, or the little pi. And then the defendant is a capital D and a little triangle. So those are good shorthand terms to use. You could use it while you read and do your research. You could use them while you're taking notes of lectures and to help you speed up your writing. So this would be only for informal notes. And then legal shorthand is great for the informal, but not the formal documents. Of course, you're going to use full formal words. All right, we're going to go into the core elements of offer, acceptance, consideration, mutual assent, capacity, legality, and legal form. And so these are the basic essential components of a contract. An offer is the first component, offer and acceptance, that is. And offer is when the initial proposal communicated by the offerer. And acceptance is the offeree's response to agreeing to the terms. Consideration and mutual assent. Consideration involves what is the value exchanged, and mutual assent means the parties agree on the contract terms. Capacity and legality is essential topic in contract law. Capacity is the legal ability of parties, and as in not minor children, not lacking mental capacity, and this ensures the contract subject matter is lawful. And then that ensures that it's lawful that the parties could make the agreement. Legality would ensure the contract subject matter is lawful. Can't make a contract for an illegal activity. And then there's a legal form requirement of contracts. Some contracts must be in writing or they're not enforceable. So that's something we'll cover off and on in this course. Every once in a while we come to the statute of frauds is what it is. All right. When you're analyzing the enforceability and performance in a contract, you always ask yourself whether the parties have an agreement and what is the subject of that agreement. What rights and obligations did the agreement create, and whether those rights and obligations were performed by the parties. And then measuring the damages under the terms of the agreement is another part of the analysis. All right, we're going to do an overview now of the contract classifications, give some examples of bilateral and unilateral, some more definitions, and some enforcement, a little bit about express and implied contracts, and executed and executory contracts and what they mean. Okay, so contract classifications are really important because what's in a word, I guess you can ask yourself. What's in a language, a logos? Sorry, my dogs keep having a little fit. Contracts are classified in a variety of ways: bilateral or unilateral, express or implied, executed or executory, void, voidable or unenforceable, and formal or informal. And a contract may have multiple classifications. For example, a contract may be bilateral, express, and executed. Bilateral and unilateral contracts. Bilateral contract is a promise exchanged for a promise, and usually the offer is made and accepted. And there's an exchange of promises that binds the parties almost immediately. If one party does not fulfill its promise, the harmed party can enforce the contract through breach of contract action. Express and implied contracts have different characteristics. An express contract is specifically stated, and each party knows the terms and conditions. And it's always prudent to record oral agreements in writing. As they say, a verbal contract is only as good as the paper it's written on. An implied contract is created by the acts of parties involved. And there are different types of implied contracts. Implied in fact contract is inferred from the facts and circumstances surrounding the transaction. An implied or quasi-contract is created by court to prevent unjust enrichment, and it often uses terms like quantum meruit, which is, the English of that is as much as is deserved. Executed and executory contracts are also important to understand. They are an executed contract is a fully performed contract, and no further performance is necessary. When we say performance, we're saying that one party or the other still needs to do something for the other. The term executed also means to sign an agreement in contract law. An executory contract is a contract yet to be performed or only partially performed. The future obligations to perform exist. The contract is binding, and and but there's a future performance. A good example is insurance. Now, the legal status of contracts. We're going to look next to void contracts and voidable contracts and unenforceable contracts. Void, voidable, and unenforceable contracts. A void contract, it never has any legal effect. It never legally comes to existence. Voidable contracts, on the other hand, may be avoided or canceled by a party, and they usually arise with minors, intoxicated persons, or mentally incapacitated persons. Can also arise when one party fails to act honestly. Until an act of disaffirmance happens, the contract may be valid. An unenforceable contract occurs when the statute requires a contract to be in writing, statute of frauds, or law that makes contract unenforceable is passed. So the law can be made that makes it unenforceable. So what was once enforceable is not. Formal and informal contracts. We'll look at the difference between formal and informal. Formal are historical requirements and current uses, and informal are modern standards and forms of today. Formal contracts were previously required under common law, and parties were required to engage in certain formalities, such as a fixed wax imprint or an insignia to the document. It had to be in writing and signed and often witnessed, and it's still used today for contracts for transfer of real estate. An informal contract is the modern standard. It's less formal. The key is expression of parties' intent, maybe oral, written, or implied. So let's review this short slide presentation. So we're going to do a summary of basic classifications. And so here we go. Remember that contracts require an offer, acceptance, consideration, mutual assent, capacity, and legality in order to be valid. And contract classifications they're classified by bilateral, unilateral, express or implied, executed or executory, and more. Contracts must follow proper form and can be formal, informal, void, voidable, or unenforceable. So I don't want to get the impression that because of the old days, how things were formalized, they were always formalized. We still need formality in contracts. So we use the forms and that sort of thing to help us with that. And mastering these basics, the fundamentals are important. It's a crucial understanding at this point, which lays some foundation to your learning as you go along in courses on contracts and or studying for the NALA exam. You'll be better equipped to answer questions on the exam and exams in class and analyze, interpret, and apply the contract law in various contexts. Recognizing the different types of contracts will also help you in your analysis. What am I dealing with? Who are the people and the parties and what's going on here? And the contract law, when you apply your knowledge of contract law, you're going to have effective interpretation and decision making in your legal context. So this concludes this lecture, the second of a series of lectures on contract law.
I hope you got some good information from this video lecture. Don't forget that I have a Teachable school account. Here is the address for that, mayananda-s-school.teachable.com. The name of my school is Mayananda. And also there's a coupon here for you to save some money. And finally, good luck on the exam. And don't forget to like, share, and subscribe.